Hello and welcome to Absolute Trust Talk. I am Kirsten Howe here with Jessica Colbert, one of our associate attorneys. And this is again a part two to our episode where we're introducing our newest associate, Ariana Flynn, and talking to her in particular about her experiences as a trust and estate litigator. We as planners are always trying to learn better ways to do things, because our goal always is to make sure that our clients' wishes are carried out. And anytime a client of ours has their estate plan challenged, that's hard for us. We don't want that to happen. And so Ariana is here to talk to our audience, but also to me and Jessica about what we can do to help our clients avoid trust and estate litigation after they pass away. Jessica, why don't you get us started today?
Yeah, so like you said, I am not a litigator. All of this is entirely new to me. So I'm curious to hear what Ariana has to say about what types of things our clients can do if they're worried that there might be a dispute upon their death.
Mm-hmm. And that's a good question. So for a client, so there are some less extreme things that they can do to more extreme. So one of the easiest things that a client can do is, after creating their estate plan, they could draft a letter in their either handwriting or in their own words, just explaining why they made the decisions that they made for their beneficiaries.
Well, I just want to say, I mean, this generally doesn't arise when mom's estate plan says, I leave everything equally to my 3 children. It's when there's some asymmetry, or, I'm leaving more to this child, less to this child, that kind of thing. You can kind of see from the plan, there's a potential for somebody to be unhappy, because people don't challenge estate plans when they're happy with them.
Right, absolutely. When there's an unnatural disposition or a weird distribution that maybe the children do not approve of or don't like, or they're reducing their share. If a client is worried that something like that, and maybe there's a little bit more than just a letter, they could also obtain, these are more the extreme scenarios, but they could obtain a certificate of independent review, which is a review by just an impartial attorney. They could also go to court and petition the court to approve of the estate plan itself.
Okay, so those are requiring the client to take a few extra steps that most people don't do with their estate plans. Most people, right, the attorney writes the estate plan and they go home, and they don't go visit yet another attorney to kind of validate it. But okay, what about I've heard of people who go and have a neuropsych evaluation done on themselves, so that in the future there's a record that on the day I signed this document, I had my brain was okay.
Right, definitely. And I think that that's a good tool to use, especially if you anticipate there's a question regarding your capacity, or there's any concern that one of the either beneficiaries or disinherited beneficiaries is going to make that trouble in the future. I did have a case when I was a litigator, where a client, the decedent, actually, the person who passed away, knew that her child was going to be unhappy with the distribution. So she actually did take these steps, wrote the letter explaining her decisions, ended up taking the psychological examination right before executing the estate plan. And that was just so impactful and so helpful for later on. Lo and behold, the son did challenge the trust based off of a lack of capacity. And that neuropsych exam was really, really impactful, because it showed that she had her mental faculties. She was cognitively aware during that time of execution of the instruments.
Yeah. And unlike petitioning the court, it's something that you do on your own. You do it privately. Mm-hmm. The children aren't going to be made aware of it unless there's a problem after you pass away, most likely. Right. Although I suppose you could circulate your test results just to calm everybody down. I don't know. Okay. Ariana, what else? There are things though, that we as estate planners can kind of talk to our clients about, and maybe procedures or policies that we can implement to sort of help shore up their estate plans?
Absolutely. So just kind of on the flip side, when there is a trust contest, the attorney's testimony is, again, it's so impactful. And I always cite the case of estate of Getz in every single case, because if there is an estate planning attorney in the planning process, their testimony is given great weight. It's very, very impactful. So taking good records, good notes of the meeting, who was there, who brought the client, making just the client sit in the planning meeting, having everyone else either in the waiting room, or if you don't have a waiting room, outside.
Out in the parking lot. Yeah.
In their car, the parking lot,
Yeah.
take a walk.
We do that with our, I'm going to say with our slightly older clients, we are kind of sensitive about that. And we will say, no, you got to come alone to the planning and also to the signing. We need you alone. And sometimes clients get upset about that. They don't like that, or it's not even, they don't like it. The children don't like it. But it's really to protect the integrity of the planning. And that's everybody's benefit, I think.
Right. And yeah, we're doing it for a reason. We don't hate your children, it's exactly for this purpose, for the preserving the evidence, making sure that, we're asking the client these open-ended questions. What do you want? Why are you making these changes? And if they have, the either influence or somebody in the room that's there, it could influence their decisions, and also breach confidentiality and just a whole load of legal issues that could come with it.
Right. There's that. Yeah. So we may ask questions that we wouldn't be asking a 35-year-old client. We might be just double checking to establish for our own written record that you knew what you were talking about, and this truly was what you wanted on the day that you talked to me. So that's why we might be a little more, unbearable.
Another thing that, in the same vein that our clients might not like so much is we sometimes make our clients come in multiple times and have the conversation with us about what they want multiple times. If, there's any indication that something iffy is going on, we want to confirm that that's actually what you want. You told us once, we want to hear it again. So sometimes that means multiple meetings to discuss these things.
Right. Yeah, that's a really good point, Jessica. Yeah. I just want to bring up one other thing, Ariana, because this is something that I have observed from being in planning meetings with you. And it's my attitude is generally to kind of lay out the pluses and minuses of a given decision. And then if I'm confident that the client understands both the pluses and the minuses, I'll let them make their decision. But I have seen you maybe push back a little more than I would when clients want to name co-trustees. They're going to say, my daughter and my son are going to be co-trustees. And I know just from watching you that must be a really gnarly thing in the courtroom.
Absolutely. I've seen the other end of it, and just the more just risks and downsides that comes out of it rather than pros. I think the only pro is I want to treat my children equally. And what a lot of clients don't understand is that, the trustee role is a job. It's not a who gets what, but it's who's doing the dirty work, who's talking to the banks, who's signing the papers. And really at the end of the day, only one person, should be doing that job. As far as making decisions, they can always still work together and both can put their input in, but it's really just the administrative portion of who's signing that paper at the end of the day. And so just there's always there's a lot more just downsides that come from it, because now you have to decide on everything together. You have to sign every single paperwork, and oftentimes these very minuscule decisions would end up in litigation because there's co-trustees. And so again, I just try and encourage clients to really think about that. And if you're having two people in place, why? What's your intent there? And kind of on the other end of that is just, who are you going to have in charge? Whether it's your,
Right.
I'm going to choose this child just because they're my eldest, child, or oh, I'm choosing this child because they are more financially responsible and can make good decisions and are able to do that job well.
Yeah. You have definitely opened my eyes around that, and I'm a little less, maybe I'm a little less passive. I'm a little more pushy on that point. And I appreciate and thank you for that. And thank you for all of the wisdom that you've imparted in these last 2 episodes. This has been really helpful, I think, to Jessica too. I'm seeing her nodding like, oh yeah.
I'm glad my litigation could come in handy. I knew it would.
Definitely. All right. Thank you all for listening. I hope you got a lot out of this episode and the last one. You kind of have to listen to them together. And that is intentional on our part. And we look forward to connecting with you next time.
Thank you for joining us today for another episode of Absolute Trust Talk Live. If you enjoyed listening in, then don't forget to subscribe. You can find us on Apple Podcasts or wherever you may listen by searching Absolute Trust Talk. While you're there, we would also love for you to leave us a review. And then why not share your favorite episodes with family, friends, or colleagues too? You can find all of our shows and corresponding show notes by visiting absolutetrustcouncil.com. You'll also find a variety of other free resources, including our ebooks, videos, blogs, presentations, and more. If you need help with your estate planning or administration, we also offer a free discovery call to help get the process started. You can find more information on booking your session by visiting absolutetrustcouncil.com/scheduling. Don't forget to keep an eye out for our next live episode. If you join us for the broadcast, you can submit questions during the show. But if not, don't worry. You can always get in touch with us by sending a quick message to info@absolutetrustcouncil.com. Thanks again for listening. We'll see you soon.